This is Power 987 Podcast. Now we're talking. Subscribe to Power 987 Podcast on iTunes or wherever you get your podcasts. There's more on power987.co.za.
23 minutes to 2, Power Lunch on Power 98.7. Now we are talking. Well, on Mondays at this time, we talk property. Property ownership is often seen as a symbol of stability and long-term investment, but things can quickly become complicated when that ownership is shared, right? Today, we are unpacking core ownership disputes, specifically what happens when two or more people jointly own a property and one party wants to sell while the other one refuses. This is a situation that can arise between former partners, for instance, after a breakup, siblings who've inherited a home, or even friends who invested in property together. And it often leads to tension, financial strain, and legal uncertainty. So in this conversation, I want us to explore what rights each co-owner has, what legal processes can be followed when there is a deadlock, whether one party can force a sale, and how these disputes can be resolved in a way that is fair and legally sound. Laurent, he's director at SBL Incorporated, is on the line with us to help us with this question, understanding co-ownership in property law. When one owner wants to sell, as I mentioned, and the other refuses, what happens from a legal perspective? Good afternoon, Claire.
Good afternoon. How are you?
Good. How are you?
Good. Thank you. Yes, thank you for that introduction.
Thank you so much for coming through to speak to us. We appreciate that. I mean, can we maybe start by understanding what co-ownership means in a legal sense and how common, if it is, in South Africa?
Yes. Okay. So co-ownership in South Africa and in a law context basically means each co-owner owns an undivided share in the whole property. So what this means is that even if I owe only 50% of the property, nobody owns only just, the kitchen or the garage. Each owner owns a percentage of the share in the entire property. And, co-ownership has become an increasingly common phenomenon in contemporary South Africa. I would say driven primarily by, economic pressures and escalating costs of residential and investment costs. But it is a Roman Dutch maxim. I won't embarrass myself by trying to pronounce the Latin on air, but it translates to say that co-ownership is the mother of all disputes.
Mm. So it's I guess a 50-50, to put it in simpler language, where people have gone into a partnership or bought a property together wholly, as owners. So there's no definition of whether somebody owns 60% or 30%. It's just that it's both our names as the owners of this property.
Yeah. So, the shares can be split 60, 40%, whatever the case may be. But, the party's entitlement to the property is basically they own, like I said, each owner owns a percentage share over the entire property.
So it can be percentage-wise, irrespective. No, right. I totally get that. So in a situation where one co-owner then wants to sell, right, and the other refuses, what happens? Who's got more rights? How does that work?
Right. So the Supreme Court of Appeal has held that no co-owner is obliged to remain a co-owner against their will. And so basically, if it is the case where a co-owner wants to sell the property, and I'm talking about the joint property, not just his share, then he does have a remedy in law to actually force a sale of the property. This is an ancient Roman Dutch remedy, and it's known as the actio communi dividendo. It basically is a remedy which exists to free owners from arrangements that they have, or when arrangements become untenable, whilst also ensuring fair treatment for all the owners. So ultimately, it basically allows a co-owner to approach court by way of an application to court to seek in order to terminate the co-ownership and also to determine the fairest method of division of the asset.
Just so clear, you did well in that Latin maxim. Because I know the first one that you wanted was the communio est mater rixarum.
Yeah, I shied away from that one.
Don't worry, I'll help you with that one. I was actually an A student in Latin, so.
Oh, wow.
So that's right up my alley. But that was a long time ago. So I want to go back to that dividendo rule that you mentioned, the actio communi, right? Because it's for, I guess, partitioning co-owned property, right? Ensuring that no co-owner is forced to remain in the partnership against their will. Is it then possible for one party to force the sale of a property, even if the other one doesn't want to? Or does it have to? Do we always have to have a mutual agreement for a sale to go ahead?
Okay. So, yeah, I think it's important that we draw a distinction here. So a co-owner may freely sell his individual and undivided share in the property without the consent of the other co-owners. But, I mean, in practice, if you think that would rarely happen because, the parties initially entered into this partnership, as you say, and it ultimately comes down to the termination of the partnership, not necessarily just selling 1/2 share in a property. I mean, if you think realistically, who would purchase 1/2 share in a property if they are not in a partnership of some sort, So, yes, you would need the consent of all parties to be able to sell the property, and that would be the joint property. However, as I've mentioned through this actio communi dividendo, there is a mechanism by which a party can approach court to try and force a sale.
How does the court then decide what is fair when resolving this type of disputes? Because I can imagine, Claire, that most of these things, if it's like, for instance, siblings, it becomes a little bit hard. Or divorced parties where there's animosity because me and the missus are no longer seeing eye to eye, but when things were good, we decided to buy this property together. So how does the court then decide what is fair? When resolving this type of disputes?
Yes. So the court's fundamental objective is to create an equitable solution that basically ends the co-ownership agreement cleanly and also ensures that neither party is unduly prejudiced. So first thing the court might do is, based on the facts of the case and what the applicant has presented in the court papers, basically to prove that there is a co-ownership agreement, there is co-ownership of the property, and basically to give the facts of which arose in the matter and the circumstances under which they are now seeking to terminate the joint ownership agreement. The court will take that into consideration and may firstly consider probably the most drastic solution or see if that is an option, which would be to consider the possible partition or subdivision of the property. However, that is rarely employed in practice because most properties cannot, practically and economically be subdivided.
So are there situations, Claire, where one party can be compelled to buy out the other party instead of selling the property?
Yes, and this is one of the next options that the court would probably consider. So basically to say, to make an order that one co-owner, basically to purchase or to sell the other's share at at fair value. So the court will require an independent valuation. I actually, get 3 independent valuations to give the court as many options as they have to make an order that is just and equitable in the circumstances. And if the parties then are not wanting or not able to purchase each other's half share of the property, and that's when the court would look at the forced sale of the property, which would typically be take place at auction. And the proceeds of the sale are then distributed among the co-owners according to their share and value in the property.
We are in conversation with the director at SBL Incorporated, Laurent. We're talking about when one owner wants to sell and the other refuses. What happens to shared property? If you've got a question, comment, by all means join us on 0861 987 000, tweets at Power98.7 or directly at Kwena Moabelo. Got a message here on X, Claire, that says, does this apply in marriage of community of property type?
Yes, and in those cases, so co-ownership will be co-ownership as long as there are more than one person owning a property.
So in marriage of community, does it automatically then become co-ownership by virtue of
in community of property, what the parties have then agreed is that the property should be sold and the proceeds should be split equally. So that will be dealt with in terms of a divorce and a decree of divorce by the divorce court, not necessarily by way of an action or an application to court to terminate the right of joint ownership. That will be done by way of the divorce.
How important is it to have a co-ownership agreement in place from the beginning? And if so, Claire, what should it include?
Well, it's crucially important to conclude a written co-ownership agreement, and ideally you want to do this before the property is acquired. The amount of risk that you're going to reduce by just having an agreement in place, the parties have certainty and are aware of what their respective obligations are, can reduce so much risk for one in the future, especially if we consider that life happens, parties change, things occur which might necessitate for someone to exit this joint ownership agreement. So, some of the important things that a written joint ownership agreement should include are basically to spell out the ownership structure, so specifying each party's respective ownership percentage, then to detail parties' respective financial contributions and the responsibility, specifying how costs are to be divided and when payments is to be made. It should obviously then also address bond repayment, bank loan responsibilities, etc. Another important one, which gives rise to a lot of disputes, is to specify maintenance and repair responsibilities. That is also really important. They should establish rules for the use of the property as well as the occupancy of the property. And then also to regulate what would happen in the event of a sale or transfer of one's share in the property. So what often is built into the agreement there is a right of first refusal, giving the other owner the first right to buy the property before the co-owner wants to sell his share or to terminate to approach court for the termination of the joint ownership. It should always contain a dispute resolution process, as well as address the triggers, the termination triggers, as well as, exit mechanisms for the parties under these circumstances.
0861 987 000, tweets at PowerFM987 or directly at Kwena Moabelo. Voice notes 083 303 7093. I can imagine though, Claire, before we go to the voice note, that most of us will not think of a co-ownership agreement, especially if it's like siblings where we are happy, we are still good, it's a marriage, we're as partners, everything is that we have this utopic idea of how it's going to be happily ever after. later. So sometimes our minds don't go that far because things are good. You don't think that, hey, it might come to a point where things are not as good and then we have to differ.
That's absolutely the case. But I want to stress that it's not too late for parties to, even if things are good and okay at least, sit down together and decide what would we do if in the event of things not being good, and try and get an agreement in place, because it will save the parties a lot of risk and undue cost in the future.
Let's take a listen to this voice note.
Good afternoon, Kwena, and good afternoon to your guest. Can you please ask your guest if maybe if you go to Masters of High Court and they say if the other party cannot agree, there's no way they can fit in. So if you cannot afford a lawyer, what is your position on that? How can you get help? Because now even if you go to, lawyers that are working for government, they will tell you that they only work at an estate of about 200,000. Above that, they can help. So what do you do if you don't have a lawyer? Thank you. I'll listen on the radio.
Claire, you got that?
That's our simple.
Yes,
okay.
I got that.
Sure.
It's unfortunate, and that was one of my points to say this is not an easy kind of application to bring to court. You need a seasoned and well-versed, attorney who has extensive knowledge of property law. You don't want to, go spend money on a lawyer only to determine at the end of the matter that they were incompetent and leave you just high and dry. But there is many people in this country who unfortunately don't have access to justice, and that's the sad truth, because of the inability to afford for a lawyer. There is legal aid. However, legal aid has a strict means test, and one of the requirements of the means test is you cannot own if you don't qualify for legal aid if you own property. However, the disputes or the very thing that they need help with is the property which they own. So this is one of the challenges. But there are other cases that perhaps would be willing to assist you, including legal. The law clinic at universities. If you're in Johannesburg, you can go approach the Wits Law Clinic, and perhaps they would be able to point you in the direction of assistance.
Let's squeeze in Senageng in Randburg. Good afternoon, Senageng.
It's Seageng.
Seageng, okay.
Seageng.
Sure.
For Claire's sake, there is the concept from this registry point of view, where there is a joint ownership. A joint owner can go to this office. You apply for a certificate of registered title for your share of ownership of that particular property. What will happen is that they'll issue with a certificate of registered title, and then it means that you yourself can sell your share in that property if somebody doesn't agree. But the other original title deed that had a joint ownership needs to be endorsed, meaning that an owner can go, each and every owner, whatever share you own, you can go and apply to this office, but it's through conveyancing system, whereby you get your own certificate of registered title, and it will only indicate your only share.
Does it allow you to sell even if the other party doesn't want to sell?
If you have that certificate, you can sell. You can sell. I believe you can sell.
Okay, but and before Claire comes in, I just want to get clarity, and we don't have that much time. So does it allow you to sell the entire property or only your portion?
Only your share. Only your share.
Okay. Okay.
Yes.
All right. Claire?
Okay, I'm glad that you qualified it with that, because yes, your share you most certainly can sell. Your share in the property is disposable. You do not need the consent of the other party to sell your share in the property. But as I was earlier on in this interview, I mentioned it, realistically, who is going to purchase one share in a property when they are not in the partnership? And that's the difficulty, where parties actually have no choice but to approach a court to sell the entire property, including your co-owner's ownership in the property. And that's the difference. But I absolutely agree. You are entitled to sell your half share in the property at any time without consent.
Okay, we've got. I'm just going to squeeze in this question very quickly. Kobela, please go for it.
Kwena, thank you, and I hope I'm not off topic, but I wanted to find out what I've seen is an interesting phenomenon where you find estates use the levy that the homeowners pay to fight the homeowner in court. Is that not considered double dipping in any way?
Okay, Claire, I don't know if you are able to answer that.
So I just want to clarify, you said, is that not considered double dipping?
Yes.
As in double charging?
Yes.
Well, in respect of a scheme, parties have given up some of their ownership rights to live in that scheme, and for which they are required to, live in that community to pay the levies. So it is if it is required that, or if one party to a scheme is not paying their dues, and the scheme is required to take legal measures against the that person, then it is required of the rest of the members of that scheme to pay for the legal fees. So that is perfectly, I don't believe that would be considered double dipping. That is the way they operate.
Just finally, Claire, we are unfortunately out of time, and we'll try and see if we can get more time the next time, because I see there's people who have a couple of questions. What advice would you give, and especially entering into a co-ownership agreement in terms of property? Would you say that exactly that make sure that you've got a co-ownership agreement in place from the beginning?
Yes, I think the most consequential mistake that people make by far is entering into co-ownership without anything in writing. And as I say, it's not too late. Think about where you're at and what the future holds to get something in place.
Claire, thank you so much for coming through to speak to us. Appreciate your time and your insight. Just briefly before I let you go, for people that want to find out more about you guys, get in touch with SBL Incorporated. Where and how do they get in touch?
They can contact us on our website, sbllaw.co.za. Alternatively, contact me on 086 100 7757.
Fantastic. Claire Laurent, thank you so much for coming through to speak to us, Director at SBL Incorporated.
You've been listening to Power 987 Podcast. For more podcasts, visit power987.co.za or subscribe wherever you get your podcasts.